Before we get started with this episode of Let's Get Surety, we want to thank our sponsor, Old Republic Surety, for sponsoring not only this episode of Let's Get Surety, but also NASBP's virtual seminars for the third year in a row. For more information about Old Republic Surety, visit www.orsurety.com. Now, let's get started with the show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande, and this is Let's Get Surety. Welcome to this episode where we're going to be talking about some recent case law and a court opinionating that if the obligee does not default the sub, then it cannot claim on the bond. So we're going to kind of talk through that. And to do that, we have with us a legal expert. We have Todd Regan. And Todd is a partner with Gordon Rees. Hey, Todd, thanks for being with us today.
Hi, Kat. Thanks for having me. I'm excited to be here. This is my first podcast ever.
Well, I'm excited to initiate you into the world of podcasts, Todd.
Thank you. I'm excited.
So this is a really interesting situation that we're talking about where the obligee is not defaulting the sub. And then, Go ahead, Todd.
So it's a recent decision that came out in a Boston District Court case that came out. It is currently under appeal, so subject to change. But it's an interesting case. It's Arch Insurance versus Graphic Builders is the name of the case, and it's not really novel issues of law or on new issues, but it's really just sort of a good example to review to remind people, what their obligations are in order to trigger the surety's liability on their performance bond, and, the sort of the reasons why there are these notice provisions, for the surety under the bond, and really to talk about what the consequences are, which are potentially dire, really, for the claimant if they don't properly follow the notice and termination provisions under the performance bond. So those are really sort of the big key issues here. It's not novel issues, but there's some interesting facts in this case, and the contractor was really in a dilemma. And I think it's interesting to note here that we're talking about a subcontractor performance bond. Typically we think of the payment and performance bonds being posted by the prime contractor in favor of the owner, which you'd often see on a private or a public project. This is a private project, and quite often you'll see on a private project larger, more important subs being required to post payment and performance bonds. And that's exactly what happened here. It was a large, important sub that manufactured and installed these prefabricated modules to be fit into the project. And they were the bond principal. In this case, the obligee was the general contractor. So I think that's an important distinction to make. And I think the concepts we're talking about here really apply equally to the more typical situation where it's the owner is the obligee on the bond that was posted by the prime contractor. So these general concepts...
This was a little bit different situation than that.
Yeah. Just I think it's important to note that the parties are a little bit different, but the principles are all really the same and would apply equally if it was the general contractor who posted the bond.
And the performance bond, was that a standard performance bond that was used in this case, or was it something that was more specific?
Yeah, no, that's a good question and a really good point here. This was the standard AIA A312 bond. That's really considered the gold standard, standard typical performance bond that's used in the industry. In my experience, it's really the most commonly used bonds. I mean, sometimes in certain instances, if it's a public project or for whatever reason, there may be bonds that are used that are different. But, most typically, if you have a performance bond, it's going to be the A312 bond. It has these very specific terms that aren't varied. And one of the reasons why the sureties are very interested in using the standard foreign bond and not allowing any modifications or changes to that is because it allows for certainty in the dealings between the parties. and allows the surety and the parties to know, going forward in the future, if there's a dispute, how the courts are going to interpret their rights and responsibilities. These A312 bonds have been around for many years. They've been amended slightly over the years, but there is a large body of case law, in the state courts, in the federal courts, in the appellate level courts. Just about anywhere you go, there's going to be case law out there interpreting what the parties' rights and responsibilities are under this specific form. So that gives the surety a certain level of certainty in their dealings. They know how the courts have interpreted in the past, and it really gets rid of the possibility of the court finding ambiguity in the bond, reading the bond in a new and novel way. So it gives the parties a real level of certainty in their dealings, and a level of confidence of how it's going to be interpreted. So for that reason, the sureties really typically prefer to use this bond form, and they don't like to deviate from it because they know how it's going to be interpreted by the courts. And in this case, that's exactly what happened. The court interpreted the bond really in accordance to its terms, and in accordance with the way that previous courts have interpreted it, which is really the key issue, that the requirement that you have to terminate the subcontractor, or the bond principal. If the bond principal is the general contractor, the same idea is that you have to formally give a notice of default, and you have to formally terminate the subcontractor's rights to perform on the project and give notice to the surety before the surety's performance obligations trigger in. And that's tried and true. There's federal case law and state case law and appellate level case law upholding those obligations, and that's exactly what the court in this graphic builders case came out with. And the facts are sort of interesting, and the contractor did their best to come up with some novel arguments around it. But at the end of the day, the court followed other decisions and said, no, if you want to have a claim against a performance bond and you want to require the surety to perform, you're going to have to follow these specific provisions. You're going to have to put the subcontractor on notice of default. If they don't cure the default in accordance with the terms of the contract, then you have to formally terminate their right to perform the project and formally demand that the surety step in.
And looking at this, that didn't happen in that case, and that's where the legal action came in. Is that right, Todd?
Yeah, and I guess just a little bit, maybe I'll just dive a little bit into the background of the case to give some context. This was a 171 unit apartment project in Charlestown, in Boston, and involved partial renovation of a historic structure, and also building of a 4-story structure to be attached to it, made out of these prefabricated modular sections. And we're talking about very big, custom-made, prefabricated units. So the subcontractor who was hired manufactured and installed them. It was a Canadian company, and these are huge units, 65-foot long, 30,000-pound units that are, completely manufactured off-site and then installed, basically kind of like Legos put together on-site.
That's becoming a lot more common. We're seeing that prefabrication installation much more commonly than we did before.
Right. Yeah, that's definitely a trend in the industry, and it has its pluses and minuses. The facts of this case definitely point out some of the challenges to proceeding in that way, and also some of the sort of dilemmas that the contractor faces when it has a non-performing sub. And so, in this case, the subcontract, there was a warranty that all the work would be free from defects, and that the subcontractor would identify for any costs arising out of repair work. And there was the 312 performance bond. But apparently, right from the beginning, and I should say apparently because I wasn't personally involved in this case, I don't have any inside knowledge of what happened other than what I've read from the decision. So I don't want to give that impression. And I know both sides were represented by very competent counsel who made very strong arguments on that. So, but apparently, according to the allegations of the complaint, there were problems from the very beginning that the job contractor had with this sub. And one of them was that they claimed that the units which were manufactured in Canada were manufactured without even having approved shop drawings, which is a huge problem right from the start, and almost seems like it's doomed to fail, because how are you going to manufacture these giant modules in Canada and make sure they fit properly, and coordinate in with the other systems of the building if you haven't had a reviewed an approved shop drawing process? And that's just sort of a fundamental construction 101 issue. So, and then apparently the problems continued on from there. There's claims that the units that were manufactured didn't have functioning or code compliant mechanical systems. So problems with the plumbing and fire protection. Apparently, also another big problem was the windows were all leaking on these things, and these were all manufactured with the windows in them, which was a big problem. I'm not sure how it works when they get delivered to site. If the windows are manufactured off site, what the process is for remedying that. Another big concern was that the units were misaligned; they didn't fit together. The exterior dimensions were different sizes. So anyhow, there were a lot of complaints with this product. The general contractor did not terminate the subcontract, but they did send several notices that the sub was in default, and sent several notices to the surety, which seems to be good practice. But these notices basically said that there was defects in the work, and demanded that the surety provide a contractual warranty and indemnification payments for the costs incurred and to be incurred in connection with repairing the work. But the contractor never formally defaulted the subcontractor. They allowed them to stay on the project, and instead asked the surety to come in and to make payments. It's almost as if the contractor was trying to treat the performance bond as almost like an insurance policy, or almost what we call in the industry as an indemnity bond. There are bonds out there that don't have these specific requirements of the E312 bond, the notice of default, the express termination. Those bonds basically simply allow the obligee to go out and incur costs to repair work, and then they can turn around and just present the surety with a bill and get paid, almost like an insurance policy. Those are called indemnity bonds. And so maybe that's what they thought that they had. It's amazing how often parties never really specifically read the contract or read the provisions of the bond.
It's important that you read that contract, right? And the bond provisions.
Yeah, and it seems like an elementary concept, but it's not. Sometimes these things, there's a lot of moving pieces, and sometimes these things, get lost in the shuffle. So, they never defaulted this. They defaulted them, but never terminated them. But it's important to note, I think, from the contractor's perspective, that they were probably in a real difficult position. This was not just some drywall subcontractor, right, who walked off the job or was delayed. That's a pretty generic scope. And you could fairly easily terminate your drywall sub and bring someone else in to perform. But in this case, these were custom manufactured, prefabricated units. That this sub was basically constructing the entire project off-site and installing it in the field. So that made it very difficult, probably, for the contractor to make the decision to terminate them. Because if you terminate this subcontractor, all of a sudden the entire project now is frozen, and any delays are exacerbated. And so any delays obviously become much more significant. And to terminate this type of subcontractor, before you have all the materials in hand, before you have all the units, does that mean they would have been required to go out and get them from some other source, or find some other subcontractor who was able to come on site and do the installation? So that would have been a real dilemma for them, and probably why they were reluctant to actually terminate them. That's my guess as to why they, were concerned about actually terminating. So
Well, and it sounds
ultimately,
like they were taking steps like sending notices, but that just wasn't what was required by the bond. Is that
right,
right?
right, you got
Yeah.
to follow the bond. It wasn't sufficient. They never formally terminated them. So what they did was they had a meeting with the surety about the project, and they sent
Hmm.
additional default notices, but they never terminated. And what they ultimately did was they hired their own contractors to come out and repair the defects, spending over $3 million. And then they tried to turn around and send that bill to the surety. And the surety said, no, we have rights here. We have rights to be involved with this process. You've got to give us notice and obligation to come out or opportunity to come out so that we can decide the best and most cost efficient way of resolving this issue. And because you didn't do that, you've prejudiced our rights by acting unilaterally. So you voided the obligations under the bond. And so then litigation ensued, as is often the case. And in this case, the surety was very proactive. I
Yeah.
think the surety must have realized that they were going to get sued by this contractor, so they proactively, threw the first punch and filed a declaratory judgment action, which is sometimes called a deck action. And basically, the surety filed suit saying, we've been put on notice that this contractor thinks they have a claim against our bond. They didn't comply with the provisions requiring termination of the sub. So we want the court to rule proactively, give a declaratory judgment that we're not liable. And so that's why in this case the surety is actually, you'll see as the plaintiff, and the contractor is actually the defendant, even though the contractor is the one that has the claims. So
Right.
and again, just the big issue that was raised on summary judgment, and the surety prevailed and got summary judgment in their favor, and had a declaratory judgment in their favor that they have no obligation for these $3.1 million in damages, was simply because the language of the bond was an express condition precedent. It followed other case law directly on point, and found that because they never terminated this subcontractor, and then went out and spent the money on their own, and then tried to get reimbursed for it on the back end, that they waived their rights. And the surety was essentially completely released from any obligations on the bond. And so that was obviously a pretty harsh decision. The contractor came up with I think, some good arguments to try to get around it, but they just weren't successful. So one of the arguments was sort of a practical argument, and
Yeah.
there's an interesting quote in there where the court quoted the contractor saying that they didn't want to terminate the subcontractor because doing so would be the equivalent of shooting itself in the face, which is a pretty dramatic statement. But my reading of that is that they were saying that if we terminate this sub, this whole project is going to come to a halt. We're going to have no other place to get these materials from. It's the whole project. We simply can't do it.
Yeah.
And the court didn't buy that argument. They said, well, you could have terminated them earlier on in the project. That's not an excuse for not complying with it. It is interesting to note that under the terms of the performance bond, if their concern was that terminating the sub would have delayed the project, or they would have been subject to liquidated damages from the owner for delays, the bond does cover those types of damages. So even if there was a terminating the sub, caused additional delays and liquidated damages, they would have been able to get reimbursing those costs, from the surety, assuming they proved, liability. And the bond also specifically states that if there are extra delays to the project and extra delayed damages and liquidated damages that the obligee is hit with because of delays in the timeliness of the surety's response, the surety will reimburse those claims as well. So they had those rights against the surety if that was their concern about delays. They could have gotten reimbursed from the surety. And quite often in the industry, when you look at projects, parties will be comparing surety bonds versus letters of credit or subcontractor default insurance, and decide what's the best form of performance security for their project. And quite often, sometimes the con listed for surety bonds is that there can be delays because you have to give the surety the opportunity to come in and investigate the claim and determine how they're going to respond to the notice of default. Whereas, in contrast for their letter of credit or subcontractor default insurance, you don't have to do that. You can immediately just make a claim and get a sum of money in your hands. But I think with these things, what's not thought of in that argument is that the sureties, they pre-qualify the subcontractors, and they're not going to write bonds for the subs unless they're very well qualified to do the work. So that's an actual, added level of protection. But also, the bond specifically says that if there are delays because of the way in which the bond claim is handled, you'll get reimbursed for those. So I think that's an important issue on that. The other arguments that the contractor tried to make, they argued that the notice provisions of the bond didn't apply to claims for repairing defective workmanship. They tried to say that because this was not a situation where the subcontractor walked off the job and didn't perform, that these notice of termination provisions shouldn't apply because the bond interprets and incorporates the terms of the subcontract, and because the subcontract allows the contractor to be reimbursed for costs of remediating defective work, that the bond should also cover those costs. But the court, looked at the terms of the bond and found that there really was no basis for that type of distinction, that the bond is clear on its face and says that whether it's a claim for defective workmanship or a claim for failure to complete the work, those termination provisions express conditions precedent and need to be complied with. So that was the holding on that issue. There was also another interesting argument raised by the contractor, and that was that because the project had already reached, or this subcontractor's work had already reached the phase that we call substantial completion, that they didn't have the right to terminate the sub after substantial completion, so they were barred from or prevented from strictly complying with this provision in the bond. And the court looked at that argument and said, well, let's look at the terms of your subcontract agreement. And the court noted that the subcontract expressly says that the subcontractor can be terminated anytime through final completion, not just substantial completion. Those are important concepts in the construction industry. Final completion versus substantial completion. And the court said, well, they weren't finally complete because final completion requires that you complete all punch list work and remedy all outstanding defective work. So because they weren't finally complete, the court said, well, you did have the right to terminate them. You just chose not to. And they quoted a statement from the contractor that they didn't want to terminate the sub because, quote, doing so did not give them the warm and fuzzies, which the court actually cited in the decision, which I think the court took to mean that they knew they had the option and the right to terminate the sub, but for whatever reason
they didn't feel good about it.
Yeah, didn't feel good about it, or maybe they were nervous about it for other reasons, and they didn't perform. So the court just rejected all those arguments. There was one final sort of last-ditch effort by the contractor, and this is something that contractors quite often do when they're unhappy with the surety, is that they try to assert a bad faith claim under the Massachusetts statute, which is known as Chapter 93A claim. And this is something that quite often when contractors are in disputes with sureties, they try to allege bad faith as a sort of a trump card to get some additional leverage against the surety.
Mm-hmm.
And in this case, the contractor alleged that the surety stated that if they did not withdraw their bad faith claims against the surety, that they would the surety threaten to end the bonding relationship with the contractor's parent company. And they said that they in fact refused, and that the surety relationship was terminated with their parent company. And the court looked at those allegations and just said they're too vague. There's not enough specific facts here to set forth a cause of action under these allegations that it's a violation if it's even occurred, whether there's some sort of violation of the Chapter 93A. So the court knocked those claims out as well.
That's interesting. So there were a number of different arguments that got brought up, but the court just kind of brought everything back to that bond form and non-compliance.
Yeah, exactly. And so that's why this is an example where it's an interesting case factually because the contractor was in a bit of a bind with this very important subcontractor who could not easily have been terminated without large consequences.
Yeah, that was a very complicated project for sure.
Yeah, and this is the key sub. They're building the entire thing, so they were certainly in a bind. So it makes it an interesting case. But at the end of the day, it just reinforces the concept that you have to strictly comply with the requirements for perfecting the performance bond claim, and that courts will apply these bonds in accordance to their terms that have been well established by many previous cases. So that's really the takeaway.
Yeah, that's a great learning. It creates a great learning opportunity for anyone looking at this case to really see as an example of why it's so important to make sure you really know what's in those bond forms and probably consult your attorney earlier versus later, right?
Yes, exactly. That's a good plug. It could be a small investment in having your attorney involved early on, but it could have very, very dire consequences if you don't, for sure. So, and definitely knowing, just like I always tell clients, is read the contract, but you also have to read the bond and understand what it means and follow what it says. That's it's hard to believe, but that's typically, or not typically, but often overlooked on these jobs.
But it's always good to have a reminder to do that, and because I know when things get busy, I'm sure people let that go sometimes. So it's important to have reminders to make sure you're doing that.
Oh, especially when there's a stressful job going on with a lot of different issues and delays and all that. So that's something that could be easily overlooked.
Any other lessons learned, Todd, from this case, or you think that's the key takeaway?
Yeah, I think the key takeaway is if you're making a bond claim, that you have to read the bond clearly and understand what the requirements are and understand that they're going to be strictly enforced by the courts. I mean, there's case law out there interpreting them according to their terms. If you deviate from those requirements, it's a very difficult uphill battle to have the court excuse for failure to strictly comply. Really.
Well, thanks for walking through that with us, Todd, today, and kind of talking about all the different issues that were involved in this case and the example it creates as a learning opportunity for all of us. It was great having you on today's episode, Todd. Sure, my pleasure. I enjoyed my first podcast. I'm excited to do it again. Hopefully we'll have you back sometime soon, Todd. I hope so.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org. Before we go, we just wanted to say thank you again to Old Republic Surety for their generous support in sponsoring this episode of Let's Get Surety. For more information on Old Republic Surety, visit www.orsurety.com.